Hi, my name is Ben England. I'm the founder and CEO of FDAimports.com and Benjamin L. England and Associates. I represent many companies all over the world before the FDA and the U.S. Department of Agriculture and Customs, primarily focusing on helping those companies comply with U.S. law to bring product in the United States. And very recently, just this year in January 2013, FDA issued new proposed regulations under the Food Safety Modernization Act. And we wanted to bring to you some big issues that we think that you ought to be paying attention to and focusing on as the FDA's regulations roll out. There's four things I want to talk about. The first thing is the fact that the statute, when Congress passed the law, failed to include in the law an adulteration charge for failing to comply with the hazard analysis risk-based preventive controls portion. Now, HARPC, which is the whole new substantive food safety requirements under the Food Safety Modernization Act, has requirements for how you identify risks and control those risks. But the statute didn't say that if the product manufactured in a facility was manufactured by someone who didn't have a HARPC plan in place, the statute didn't make the food adulterated. And the question was, what would FDA do with that? How would FDA handle it? Under the statute, if I failed to comply with HARPC, the government could prosecute me criminally, but they couldn't do anything about the food per se. Well, FDA decided to essentially write portions of the law for Congress because Congress apparently failed to provide the adulteration charge. So FDA modified what are called the Food Current Good Manufacturing Practice Regulations. These are Part 110 in FDA's regs, the sanitation regs primarily. And what FDA did was they just sort of stuck in there a clause that says if you fail to comply with HARPC, then your food is adulterated under a provision of Food and Drug law. Now, FDA had to essentially rewrite the law to do that, but they've been known to do that before. It's something to watch and something to comment about when you deal with the FDA over these proposed regulations. Secondly, another major portion that we found interesting about the Food Safety Modernization Act is even though it's risk prevention minded, the goal is to try to prevent risk. HARPC in particular required food companies to establish, essentially mandated the requirement that they establish a recall plan. Now, I happen to think that's a wise thing to do. I think companies should have a recall plan. But it does beg the question, how a recall plan is preventative in nature, when in fact, by the time you get to a recall, you've already had a food safety problem. One thing I can say about FDA in this case is at least they followed Congress's language. With the adulteration charge, they basically made it up because the statute didn't have it. Here, the regulation at least follows the language of Congress, and they're doing what the legislative branch told them to do and the president signed. The third major point has to do with the requirement that food companies that are under HARPC must have qualified individuals, people who have sufficient education and experience to properly perform some of the steps in HARPC. Now, that also seems to make sense too. But I want to read a little bit of the language so that you can understand what FDA's regulation says about it. Under the regulation, FDA says that the person who is considered a qualified individual must complete training under a standardized curriculum that's recognized as adequate by FDA or have experience that FDA recognizes as adequate. Okay, well, that sounds like a good idea, except how is the FDA going to define adequacy with respect to food quality training in food products that FDA doesn't really understand what the risks are about? So I think it's going to be a bit of a challenge for the industry to figure out how to satisfy that requirement. I also think it's going to be quite expensive. Now, FDA estimated the cost for this provision at a certain number. I think they've grossly underestimated it. The fact of the matter, it's going to be far more expensive for companies to find people or actually qualify people in order to meet this requirement under the regulation. And the fourth and final thing that I wanted to talk about today has to do with some modifications FDA made to their food sanitation regulations. Now, FDA's food sanitation regs have been around for a long time. We're talking 40, 50 years. But for most of that time, the language in the regulations where they were recommendations. There were a lot of shoulds in the regulation. A company should do something, they should do this, they should approach things a certain way. The regs were written that way because the food industry is so broad It's so varied and it's so vast. And so trying to write regulations that are very, very specific was very difficult. Well, under the HARPC regulation, at the same time that they passed the HARPC regs, proposed regs, they also proposed changes to the FDA's food sanitation regs, changing in several instances the word should to must. Now that makes a difference, because if it should, then it seems to me that companies have the ability to have a discussion with the FDA as to whether what they're doing is appropriate or not, or whether a provision even applies to their facility because of the kind of food or the kind of processing steps that they undertake. But when it becomes must, no longer do they have that opportunity to have that discussion. They must, in fact, do what's in that regulation or they're violating federal law. But when the FDA is making these shifts, these sort of subtle shifts, it actually has a significant impact on industry and how they're going to meet those requirements. And we'll see. These regulations came out January 4th, 2013. They were a year late and I think quite a number of dollars short as far as what's in them. There's a lot of ambiguity and a lot of vagueness in the regs, and we'll see how FDA intends to implement them. Now is the time to comment. Now would be the time to reach out for assistance, to review them and understand them so that you can get comments into the agency and make your voice heard. Thank you so much for listening. This is Ben England with FDAimports.com.